Hello again. I was going to avoid the subject of Alex Belfield during the rest of his trial, but the trial has now ended rather abruptly, so a few words might not come amiss. 7 weeks had been set aside for the case at Nottingham Crown Court, and after the prosecution ended its case yesterday, it was expected that the defence would begin. This has not happened, and nor does it appear that it's going to, which is a little unusual. At this time now, the defence would normally start calling its own witnesses, and the defendant would also enter the witness box so that he could be questioned by the prosecution. Alex Belfield has essentially mounted no defence, but is merely making a statement from the dock. This means that he cannot be questioned about what he says, for he is not on oath. I have no idea who advised him, if anybody, to adopt this course of action. What he is saying, in effect, is that he has no case to answer, and he's inviting the jury to regard the prosecution case as not being sufficiently robust to convict him of. This sort of strategy sometimes pays off, but it carries certain risks. For instance, rightly or wrongly, it often creates an unfavourable impression if a defendant refuses to give evidence on his own behalf. The judge alluded to this idea when he told the jury that they must not convict Belfield wholly or even mainly on his failure to give evidence, which does sound slightly ominous. I must confess that I was a little surprised to discover that there was to be no defence case, and it remains to be seen what the jury will make of this. Of course, it's for the prosecution to prove their case, not for the defence to prove innocence. And so if Alex Belfield thinks that the evidence produced was not enough to prove him guilty of these charges, then he's perfectly entitled not to present a defence and just say that the case has not been proved. We shall find out next week how this strategy works out.